All rise to the Honorable John Roberts. You may be seated. Case number 7829, State of Iowa against the United States Government. Legalization of marijuana in the state of Iowa. State of Iowa, do you have any opening statements? Yes, Your Honor. Ever since the founding fathers of our great country created the Constitution, they built the idea of federalism right into it. In Article 4, Section 4 of the Constitution, it is stated, "The United States shall guarantee to every state in this Union a republican form of government." This means we, as in the state of Iowa, can create any law we so desire. Objection. Proceed. The Constitution doesn't say you can make whatever law you so desire. This isn't just any law, and it sure isn't unconstitutional. Objection. Overruled. Nowhere in the United States Constitution does it say we can't smoke marijuana recreationally. It's a Schedule I drug. That doesn't mean it can't be legalized. It does mean the federal government has control over its use. The drug isn't as bad as it once seemed. Once seemed? Mr. Sawyer, please. The drug is still addictive and leads to later problems in life. Mr. Sawyer, please be seated. It's not a safe drug and it never will be. The United States government... Mr. Sawyer, it is not your turn to speak. Please be seated. Sorry, Your Honor. In Article 18, Section 16 of the Colorado State Constitution, it is stated that its citizens can use marijuana for recreational use. How come you didn't bring them to court? Mr. Sawyer, do you have any opening remarks? We do, Your Honor. On May 1st, 1971, the Controlled Substance Act took effect. In Subchapter 1 of this act, it talked about a Schedule I drug. Excuse me, Mr. Sawyer. Yes, Your Honor? Can you just please state the definition of a Schedule I drug for the record? Of course, Your Honor. According to the DEA, a Schedule I drug is defined as drugs with no current medical use and a high potential for abuse. Thank you, Mr. Sawyer. You may continue. Thank you, Your Honor. Some examples of Schedule I drugs are heroin, LSD, and marijuana. According to the Substance Control Act of 1971, Schedule I drugs cannot be sold or bought in the United States, giving the federal government jurisdiction over states and making sure they cannot legalize it. Thank you, Mr. Sawyer. This concludes your opening statement, Your Honor. At this time, we will let each side bring up a point to defend their case. State of Iowa, you may go first. What is your point? We'd like to bring up the subject of Schedule I drugs. Your subject of Schedule I drugs is accepted. You may proceed. A Schedule I drug, as Mr. Sawyer put it, is a drug with no medical value and high abusive rates. The state of Iowa, and I'm sure every other state that has legalized marijuana, would say that marijuana is not as bad of a Schedule I drug, say, as heroin is. We see marijuana as more of a Schedule II or a Schedule III drug. Objection. Yes, Mr. Sawyer. The federal government and the DEA still see marijuana as a Schedule I drug, even compared to other Schedule I drugs. Thank you, Mr. Sawyer. Mr. Morrison, you may continue. American Addiction Centers surveyed 1,004 people about the subject of marijuana versus alcohol. The following are some results. The first thing those 1,004 people were asked was about dangers. When looking at marijuana, it was seen as not very dangerous to somewhat dangerous. And when looking at alcohol, it was seen as somewhat dangerous to moderately dangerous, meaning that in this survey, alcohol is more dangerous than marijuana. Objection. Hang on, I'm not done. 67% of those 1,004 people said alcohol was more addictive than marijuana. And when looking at major concerns such as public behavior, obesity, ability to get sexual consent, cancer, and dying under the influence, alcohol scored higher concern rates than marijuana did, meaning that alcohol is more dangerous than marijuana. Mr. Sawyer, does the U.S. government have a point they would like to bring up to the subject matter? Yes, Your Honor. The United States government would like to bring up the issue of medical use. Subject to medical use is accepted. You may proceed. Being a Schedule I drug, marijuana really has no medical uses. Objection. Defense. Some marijuana strands have higher doses of CBD and lower doses of THC. These CBD doses help with pain relief more. CBD is actually legal as long as it doesn't have 0.3% or higher THC doses. Recreational marijuana is still a Schedule I drug and has no medical use, so therefore it should remain illegal. All rise. You may be seated. Before I read the verdict my fellow justices and I have come to, does the state of Iowa or federal government have any closing remarks they would like to say? No? Okay. Today, November 5th, 2025, for case number 7829, State of Iowa against the U.S. government over legalization of marijuana in states has come to a close 5-4 verdict in favor of the state of Iowa. The recreational use of marijuana is not seen as a federal issue, but as a state issue, and the government making laws about illegal substances is unconstitutional. Only states have the power to create laws for their substances and decide what the best use for their state is. Case number 7829 is adjourned.